Justice Breyer, welcome.
That's true. I was born in San Francisco. I am a San Franciscan, but I have lived here for almost 50 years. And after about 30 or 40 years, people begin to think, well, Massachusetts, Boston, I mean, yeah, maybe he is really a Bostonian, Canterbury. And it's wonderful to have seen the library growing in this time, too. It really has. I mean, it's an institution reaches out to the community. I just love that. I've seen that happen in Boston. I've seen that happen in Los Angeles. And all these pessimists who say we're all going to have the 2-year-olds there, the 22 months he is, and they're all just going to spend all their time on the subway reading these tablets. They've been proved wrong. At least they can read their tablets here. It's really happening. And you look at the audience, you look at today, reading the Constitution, just terrific. Now, it is true I work with this document. And it is true, at least those who read it today, and many people know it. They say, yes, we worship it. What's in it? What's in it? That's a different question. And it's an important question. So when I try to explain it to audiences, and you see each of the 40 people who read will know that part. They'll know that part, and that's great, because that'll lead them to read other parts. And it is worth reading. It isn't that long. It's not even as long as this. The Declaration of Independence fills up a lot of this book. And it's only about half. And what does it do? Well, if you ask my colleagues and me, we'll all agree. It doesn't matter what disagreements we have. We'll all agree on what the basic outlines are. And the basic outlines are, it is a constitution, so it constitutes something. What? A system of democratic government. The institutions it sets up were or have become democratic institutions. But it's a special kind of democracy. It's a democracy that divides power. States, federal, legislative, executive, judicial, 3 branches. And the reason it divides power, as it's turned out over time, is that helps us make certain that no single person or group of persons become too powerful. Yeah, that's called checks and balances. Not such a bad idea. And then it protects basic human rights. Go look at those first 10 amendments. Massachusetts would not ratify them for a long time. I was standing in the National Archives, and I look around, and there is a letter from Senator Saltonstall written in 1938 and saying a month ago the Massachusetts legislature decided to ratify the Bill of Rights. It's true, I thought that was a good idea. Well, they didn't think they went far enough, you see, but they've come around. And so protecting basic human rights, assuring a degree of equality, equal respect under the law, and a rule of law. It says that, a rule of law. Well, what's that? I tend to think it's a continuous fight against the arbitrary. What's the arbitrary? That's what King John did before the Magna Carta. I don't like you, I'll put you in jail. That's the arbitrary. The arbitrary, the despotic, the tyrannical, the capricious, the unreasonable. And there are a lot of laws in America that do that. We're talking to some Russians sometimes. I said, I want you to read the Administrative Procedures Act. They said, oh, really? Do we really have to? I said, yeah. I said, why? Because it says there what it says in a lot of countries, but here we mean it, that a rule that is irrational, a rule that is arbitrary, capricious, abuse of discretion is not a law. And that's what it means when it says here, too, rule of law. Can't put you in jail, take your life, liberty, or property without due process of law. Rule of law. So you put those together, that democratic system, system that protects basic human rights, that assures a degree of equality, that divides power horizontally and vertically so that nobody can get too much of it, and a rule of law. And now the rest of it, sort of elaborates on those points. And it does. Not all of it, I mean. I had to write an opinion once on the tonnage clause. Now, there was somebody here today who read the tonnage clause, It's not the most exciting part of the Constitution. I would like you to know there never, I don't think, had ever been an opinion written before or after. So I am the world's expert on that. True. And what is it that we do with this document? I mean, they're fine words. And by the way, why do what we do on the Supreme Court, in respect to this document, it's only some of what we do, because most of what we're doing is we're interpreting federal statutes made in Congress. And that's a small part of American law. Most law is made in the states. But we interpret those federal statutes, but we also see whether and decide whether a law of the state or an action of a government official or a law of the federal government is consistent with those basic words and principles that are encapsulated here. And as it's turned out over time, we have the final word. In principle, we have the final word. Now, I would like to make 2 points, and we can have maybe 3. The first is, you already know the third point, so when I get to it, you'll know it by heart. First point is this, that I'd like people to remember. Why us? Why us? Mm-hmm. I mean, we're not elected. 9 people? I mean, why? And Hamilton, Alexander Hamilton, and if you don't know Alexander Hamilton well, have your children and grandchildren take you to the theater. When it comes here, it'll be less expensive by the time it gets here. And listen, that's fabulous, that play. It is really good, that musical. And every child in America is learning the words and probably already knows them. He probably did too. But and it is really good. It is really good. It is not a cliche. It is just amazing. And at Hamilton, he had the right idea, and he wrote about this, and he said, well, look, why don't we give the power to set aside laws that are unconstitutional to the president? I'll tell you why, he says. We don't want to give him that power, because he has too much already, perhaps. And he has the power to say that whether what he's doing is constitutional or not. Don't kid yourself. He'll say all the time that it's constitutional. I mean, he says it much more politely and elegantly, but that's what he's driving at. Well, what about Congress? Congress, after all, is elected, and some countries have tried that, put that power in Congress. And what he basically says about Congress is this, look, Congress will be fine when what they do in saying a law is unconstitutional, for example, is popular. Believe me, they are popular. I mean, they know popularity. They are experts. And if, in fact, they do not know popularity, well, they won't be in Congress very long. Right. So, here, this document gives exactly the same rights to the least popular person in this country as to the most. And so they'll be fine when we're talking about the most, and they won't be so fine when we're talking about the least. And so that won't work. Well, who else? They say, well, these judges, perfect. They're gray. Nobody knows who they are. They're not all that powerful. They don't have the power of the purse. They don't have the power of the sword. They won't go too far. Perfect. Let them do it. And that's sort of, I paraphrase and exaggerate what he says, but that's really basically the idea. And that idea was there long before what every law student knows, Marbury versus Madison and John Marshall. John Marshall did not make this up. The founders, in fact, thought that it would work out so the judges would have the last word interpreting most of these words in the Constitution. And it turns out they did. All right? Now, if we have them doing it, Hamilton did not answer a rather important question. Remember? They're the least powerful. No purse, no sword, but they will decide for the unpopular person. But why will anyone do what they say? There's a question. That's, I think, Hotspur's question in Henry IV. Shakespeare knew about that question. You have Owen Glendower, he's a Welshman, very fiery. He says, I can call spirits from the vasty deep. And then Hotspur, who is your practical Englishman, says, well, so can I. So can any man. But will they come? when you do call for them. Right, right. And how do we know? Now, that's an important question. And that was a question that was long unsettled in the United States. Andrew Jackson, after all, after John Marshall said northern Georgia belongs to the Cherokee Indians, which it did, and the Georgians grabbed it because it had gold, and they said, why should the Indians get the gold? We should have it. And John Marshall and the court said, no, that land belongs to the Indians, and John Marshall supposedly said, Andrew Jackson supposedly said, John Marshall made his decision. Let him enforce it. And he sent troops to Georgia, but not to enforce the decision. He sent troops to drive the Indians out, and they went along the Trail of Tears to Oklahoma, many dying, and their descendants live there to this day. Go back and read what some of us know, but the younger ones don't. They can remember that day. They can remember what happened after in 1954, when the Supreme Court said equal protection of the law means no. That legal segregation in the South means no. It means no. And you think that that's equal protection, there must be something wrong with your head. Look at it. Look at it. Of course it isn't. Of course the answer is no. And they decide that in 54, and what happens in 55? Nothing. And what happens in 56? Nothing. I mean, virtually nothing. And what happens in 57? A judge in Arkansas, Little Rock, says those Little Rock 9 should go into that central high school. That's what he said. And Governor Faubus stood in the doorway, or effectively, and said, he may have the order, but I have the militia. And they couldn't go in. Famous picture, Elizabeth Eckford walking off. Hazel Bryant, her face, rage. White student. Black students in our school. And Faubus went to see Eisenhower and agreed he would let them integrate, and then he walked out and told the press the opposite. Okay? Eisenhower was pretty annoyed. Eisenhower was told by. Right? I know, it was a sad story, actually. True. But the president was told by Jimmy Burns, who'd been on the court and who was governor of South Carolina, was a moderate on race. He said, if you send troops, you're going to have a second Reconstruction. You're going to have to reoccupy the whole South. But Herbert Brownell, his wise counselor, said to him, you better do it. And within a day or two, he'd said, I will. And 1,000 paratroopers went from the 101st Airborne. Everybody in 57 knew who they were. They were the heroes of the Battle of the Bulge. They were the heroes of Normandy. They got hung up on those steeples, had been shot down, and they were heroes across the country, and 1,000 of them went to Little Rock and took those children by the hand and walked them into the school. That was a great day. Great day for the law. Great day for race. Great day for equality. Great day for the United States of America. And I wish I could end the story there, but I can't. They stayed in that school for a few months until the troops had to withdraw, and a segregationist school board said, no, out. But that case went up to the Supreme Court, and the court, all 9 justices, do it, do it. You can't get out of this, do it. 9. It could have been 900, 9,000. This is the entire South that we're talking about. And so the next day, Governor Faubus closed the school. All of them. Read what happened. Read what happened. Here in this library, they probably have 42 books on this subject and quite a few on tape, and read it. Because that was not a happy day for either black or white students. And they were out of school for quite a while. But the die was cast. It was cast. And we had then Martin Luther King, and we had bus boycotts, and we had the Freedom Riders, and we had lots of people who were not lawyers, who were not judges, but who had worked out what was going on, and it was too late to turn back. And while today isn't perfect, that mantle of segregation, legal segregation was dismantled. And when I think of all those other people down there, I once asked Vernon Jordan, who was head of the Urban League at the time, do you think the court's decision really played a role? He says, of course it did. Of course it did. It was a catalyst, but it couldn't do it by itself. And that's the point I try to make. That's the point I make. I make that point when the president of Ghana's court, a woman who's trying to bring to Ghana more democracy and more protection of human rights, and she says, why do people follow this? Why do they do it? And I said, the ones you have to convince, not the judges. Of course they agree with you. That's their job. Not the lawyers. I mean, they have an interest in it, of course. But people who aren't judges, who aren't lawyers, you go to the villages and you explain to the villages and the towns and the cities, and you get the judges and the lawyers to help you and explain why they should sometimes follow a decision of a court, which they think, by the way, they think it affects them. It's very unpopular, and it might be wrong. When we're 5'4", which we are, not that much, but maybe 20% of the time, somebody's wrong. Okay? But people follow it. Even Bush v. Gore, you want a tough one. I was in dissent in that. All right? But I heard Senator Reid say the remarkable thing about that is there weren't people murdered in the streets. They weren't firing machine guns. When I spoke at Stanford, I said that, and I said, I can tell you, if you think there should have been a few riots. Before you decide that, you go and turn on the television set. And you see how people decide things in countries where they don't follow opinions they don't like, which might be wrong, which might affect them, etc. You see? That's called rule of law. Doesn't always work out in your favor. I mean, I sit there and think it should work more in my favor. But, I know it's a big country. People think different things. And that is system, okay. It's bringing us a rule of law, a great treasure, a great treasure. So my last point is just when I tell this to a group of students, or not, I say, remember, it wasn't judges and lawyers alone that brought that day. They just had some of the Little Rock Nine speaking over at Harvard a couple of years ago. I went over there. They said they're interesting. They've had interesting lives. And a couple of them said, no matter what we do in our life, we're always going to be known for those few days. True, because they made a difference. Very brave. And they made a difference. And they made a difference to this. They made a difference to making this real. So what I say to the students and the others who will listen, and particularly the younger ones, I want to say, well, the older one, it's our job to transmit it. The younger ones, I say, I can't tell you what your life is going to be. None of us knows. And I do hope you find a good profession. I hope you find makes you happy, and I hope you find someone to love, and I hope that you work part of the time in something beyond yourself. In government, politics, library commission, art museum, school. I mean, part of us is part of the community. And I can't tell you to do it, but I can tell you I've spent a lot of time with this document. So all I can tell you is that it foresees that you will participate in public life in some way or other. It foresees it. And Adams and Hamilton and Madison and the others, I'm pretty sure, would have said, if you don't participate, it won't work. So, that's tough, but they think it. And I certainly think it, and you certainly think it. And so, what can we do? Well, have days like today. Perfect! Thank you. It won't just waving this document. You know what's in it? You think about it. You think about how it affects the country, about how it allows us to live together, a country of 320 million people of every point of view under the sun. But it's done it, not perfectly. We did have a civil war, we did have slavery, we did have segregation, we've had all kinds of stuff, but we're still here. And they thought, Washington, Hamilton, Madison, that it was an experiment. Lincoln, my God, I've got to keep this experiment from failing. Read the Gettysburg Address. My grandchildren's supposed to memorize it. But read it, you'll see that's what they think. It's still an experiment. And days like today, in my opinion, really help that experiment to continue and to work. Thanks.
Thank you so much, Justice Breyer. We're going to go right into the Q&A. And who has the mics for the Q&A? There's a stand here, Zoe? Okay.
If we can just have people kind of line up this way, and we'll take questions.
Hello, Justice Breyer. My name is Brian Davis. I'm a rising 3L at the University of Houston Law Center. Thank you so much for joining us today. My question, and a question on behalf of some friends of mine, we think that the reality is, and this relates to the recent addition of Justice Gorsuch to the Supreme Court. We think that the reality is that so much of the future of reproductive rights and civil rights is going to ride on the relationships between the Supreme Court justices that hopefully are being strengthened or formed behind closed doors. Can you kind of maybe shed some light on how the justices have kind of received the new controversial addition to the Supreme Court? And can you shed some light on, if, friendships are being formed, bonds or conversations are being had?
I was just talking to him about that the other day. And he sees it. He sees it. I've been there quite a long time, more than 20 years. I've never heard a voice raised in anger in that conference room. I've never heard one judge say of another something denigrating or insulting. We get on. We get on. The discussion is professional. It is, you listen to the other person. If you're not listening to what somebody else says, you're not going to convince that person of anything. What did you say? How can I work with that? It'll be the same. It won't be quite the same because what Justice Byron White said years ago, he says, with each new edition, it's a different court. I mean, the interaction is somewhat different. But that isn't the main thing. The best way to see what's going to happen in his case is, and the good reporters, where it's their job, that's why I'd like to encourage reporters, Linda Greenhouse, others, to make it a career, or a long time anyway, read the briefs, read the arguments, and make up your mind, just like a judge would. And you'll probably be right. And we're unanimous 50% of the time. We probably 5-4, maybe 20%. Not always the same 5 or same 4 by any means. And I counted. I was interested, because I say this because the journalists want to sell newspapers, okay? And so what you will have the impression, and this is our biggest problem, so I mention it, is everybody thinks we're junior league politicians. Well, if we're politicians, we're pretty bad ones. And it's not that. It isn't that. What is it? Because you think, well, in these major cases, like you say, reproductive rights. Look, Roe v. Wade was decided in the 70s, about 40 years ago. There have been case after case after case after case that's reaffirmed it. Now, you can never say about anything it could never be overruled. If we said you could never overrule a case, we'd be sitting here with separate but equal. So you can't say never. But boy, when a thing is embedded in the law, it's hard to overturn it. And everybody understands that they can overturn that case, then somebody else could overturn his case, and so forth. So there is tremendous stability in the law, much more than people want. Much more than, well, I shouldn't say that. I mean, they want it if they think about it. They want it if they think about it because people have to plan their lives. And you need stability, even when it's wrong. I mean, you need stability. Okay, so that should be somewhat reassuring. And also reassuring, even if the points of view that are different. I mean, Nino's vote made a difference in 4 cases a year ago out of about 75. So 2 were big deal cases and 2 weren't. See, I'm trying to give you a impressionistic idea that it is less than you think. It is a lot less. Now, where are the differences? Very often, they're not really anything you'd call political differences. I mean, they're more, call it jurisprudential if you want. I mean, I like to think, Nino Scalia and I used to go around to colleges and so forth and talk about it, and I think he's one of the big differences between us and was he likes to get cases to work out rules. And I don't like rules as much. I'm not against rules, but I mean, I worry about rules. Life will come back and hit you in the face in some unexpected way, and so I'm more comfortable with a mess. Now that accounts for a lot of our differences, a lot. By the time you're in your 50s and so forth, and you're appointed to the court, whatever profession you have, you'll have views. I mean, you'll have views on a very abstract level. What's the country like? What's law like? What's this document about? Very abstract. And there it can make a difference, and it can differ. And where are they formed? They're formed by your life. I was born in San Francisco. I did go to Lowell High School. I did end up here for 40, 50 years. And of course, it does. You can't jump out of your own life. And so things like that actually probably help shape on very close questions when you're interpreting a word like liberty or the freedom of speech, whether you think it's more this or more that. And all that, I don't think you should jump out of your own life. You can't, anyway. See, it is a big country, I said that. I used to think, why doesn't everybody agree with me who's so right all the time? Ha, ha, ha. Okay, but I came to, look, people do, 320 million people have been able to live together. And my goodness, if you, in my job, you see that every day. And you say, thank goodness, thank goodness. And so I've tried to just wander around this question because it's a very good question, but to try to give you some impressions that will make you a little less worried. Right.
Justice Breyer, my name is Lauren Souza, and I'm from Marblehead, Massachusetts. I'm going to read my question. How would you advise the how would you advise the human citizens of our United States get back to their individual vote in the true sense of democracy as intended by the framers of our Constitution? In other words, how do we, the people, permanently change Citizens United decision, especially since we cannot do that by legislation by individual states, because that would be challenged and lose in Supreme Court?
Well, how far can I go? Citizens United is a decision, and if you read it carefully, you see it may not be quite as far-reaching as you would have that impression in the end. So I actually think there are a lot of things you can do. I mean, Congress has a lot of laws they can pass, and maybe it's somewhat less of an obstacle I mean, they've never tried to regulate independent expenditures by independent persons who don't coordinate, or never said you couldn't have coordinated expenditures, and never said what the definition of coordinated was. And what about in Europe? They have quite a lot of free television time, and they put people on that free television time. So I think in my own mind that it isn't so absolute as sometimes you have that impression. I was in dissent. I don't think it's right, but nonetheless, it's work on it. and then you don't have to say overrule it either. You don't have to say overrule it. There are a lot of different things. I mean, even the majority in that case said, well, disclosure legislation is constitutional. And there are a lot of areas where that might be useful. And there are various things. So if I had a magic formula, I wouldn't tell you. I wouldn't tell you, because then there'd be some, newspaper article, which there shouldn't be, and I'd be in trouble. But I can say work on it.
We are.
All right.
My name is Boris Zubak. As my name telegraphs, I'm Russian. I was kicked out of my own country, which was a place of systematic tyranny. And and abuse of people, and came to this country as a personal paralegal attorney general of the United States. At the time, I saw with enormous fascination the Watergate proceedings. And I thought that I was essentially in the ante-chamber of paradise. I was in the lobby. It was a bonfire of democracy, as I thought, with provincial lawyers with regional accents making the most powerful people in the United States sweat publicly and writhe there, mired as they were in their lives. Now, many years later, what I witness does look and sound, Judge, as a beginning, if not already started, constitutional crisis. So my question is, at the time when every power center in our country is compromised, executive branch, to some degree even military service, although it's still the most advanced part of our society, organized part of our society, our education and all others, including the press, do you see any role for constitutional lawyers, both academics and retired federal judges, in beginning a systematic process of re-educating people who had gone now in 5 generations through social studies rather than that study of history, who have not had any civics really training since the early 60s. Do you see any role for your colleagues on all levels of the judiciary in helping our people to wake up to the true meaning of what we are witnessing?
Well, you just give an excellent example of why I think it's important for people to read this document. Of course there's a role. And of course, one thing that Sandra O'Connor and Tony Kennedy and Ruth and all of us used to really try to get people to do is, where is civics in the high schools? Where? We all took it. That's why I say, you know, you put it in a nice way, and I try to do it, but you get, on law day, the lawyers can go talk to the high schools. Over here in the federal courthouse, one of the things we wanted, and the bar has cooperated, is they bring high school classes in. This is what a court's like. And so they get an idea. And so they read the document, and 1,000 ways. But I quite agree with you that unless many more people, constitutional lawyers and lawyers in general, can try to help on law day, talk to the newspaper editorial boards, run an editorial. I mean, there are millions of ways. That's what Tocqueville said. You know, when he came over the United States, he said, well, the thing that worries me, but I find fascinating, he says, the clamor. What's the clamor? Is everybody talking at once? He says, but they're debating things. They have their societies. There's the police society. There's the Civil Liberties Union. There are seminars on the weekends. There are all kinds of coffee clatches, they used to be. And there are thousands and thousands of officers elected in thousands and thousands of different communities. And to say that the younger people have to be told by the older people. We're not the first ones to say it. You know, I think probably Methuselah was the first one, or I don't know, Moses or somebody. But I mean, but that's true. So you say, of course. Is it possible? Sure, it's possible. Sure, it's possible. And even if it weren't, we should do it. I mean, what you do is you that's what, you say, well, our role in all this, I know there's a lot of stuff going on, but we decide cases. When there's some action, and a lawyer says, or some client says, no, that act there is violative of the Constitution, it may come up to us. And then what we do is we do our job. And our job is to decide the case. The person who makes the act may be right. It may be constitutional, or may be wrong. So we had the 4 Guantanamo cases. I think we decided them in favor of the person in Guantanamo. You know? Not the most popular, bin Laden's driver. And against the President of the United States, or against the Secretary of Defense, very powerful people. But George Bush, when we decided it, said, I don't like the decision, I think it's wrong, but I'll follow it. Al Gore, when he lost Bush v. Gore, which I was sorry he did, I was in dissent on the main point there, said, don't trash the court. Both. I don't know if they were aware or not, but both were showing a change in the country from the days of Andrew Jackson. John Marshall made his decision, now let him enforce it. Now, everybody has a role in that. Everybody has a role in that. And you say, is it impossible? Of course not. Teach civics in the high school? Absolutely. Have this democracy day? Great idea.
Thank you. Thank you for your service, Your Honor.
My name is Justin Grantson, and thank you for spending some of today with us. We really appreciate it. You touched on this a little while ago about how a big part of your career has been having productive discussions with people with whom you have profound disagreements. And I would love to solicit from you some advice towards having or encouraging productive discourse with those with whom we have significant disagreements with, especially with an eye today towards alternative facts and an era where we seem to be unable to even agree on the basic tenets of reality. How do we have those discussions and move us forward?
Yeah, well, the most I learned from that was from Senator Kennedy. I put on a cup, my law clerks gave me a cup, and I give them this cup, and we put the 8 things I learned. I loved working for him. I loved it. I'm sorry, I just loved it. And it was, you get in the morning, it was fun, it was exciting, he had a good sense of humor, and he wanted something accomplished. So the first thing I put on the cup, because he'd say this, the best is the enemy of the good. You're not going to get the best. Better to get this much, an inch, than to go down to defeat and say how right I was. You know, your mother may care, but I mean, the world doesn't. and so the best is the enemy. The second thing is, and this is good, but you'll see how it fits really for everyone. I tell this, it fits for everyone. He'd say, don't worry about the credit. I mean, credit is a weapon. If you're working for something and it succeeds, there will be plenty of credit to go around. If it fails, who wants it? And the way that I would see him work is, you don't say in a compromise, it isn't a compromise to say, okay, I'll go this far and you go that far so we get to the middle. No, that's not the way to compromise. That, in his view, the way to compromise is you listen to the person who is totally opposed until eventually they'll say something you sort of agree with. If they go on long enough, they will. And then you say, what a good point. What a good point you made. What a good point. Let's see if we can work with that. And then you sit down and you try to work something out, and if it does succeed and you get the law passed and the press is there, what do you do? You push him out. You know, Senator so-and-so was so helpful on this legislation. Great. Don't worry. There'll be enough credit to go around. And so I'd say, stay calm. Stay calm. And I tell the 5th graders, my Ansel, my grandson's class, I said, gee, you know, you all get excited about some argument and say, we're used to that in our house too, but I mean, that's not going to help you. The person on the other side, they'll just think, well, you don't have a good argument at all. You're emotional about it. Stay calm. Listen to what they say. Work with the other person's ideas. I can't guarantee that will give you success. And maybe that's just the lawyer in me or the judge, you know. But that's what I did learn from Kennedy. And it was great fun, and we did accomplish a few things, and glad I worked there, and that's the best I can pass on.
Thank you very much.
So given that the Constitution is a changeable contract, what do you think of the Convention of the States project, which has 12 states signed on for the convention, and how would you change it?
Well, I'll tell you, my father, there was a city charter in San Francisco, and 1930s, and they provided they'd reopen it, and 40 years after that, and he ran for the convention that did it, and he came back and said, oh my God. He says, a great idea, as long as you're the only one there, get your way. There's going to be a lot of people, and you don't know what they're going to do, and they ended up not doing anything, luckily. And so I'm a pretty conservative on that, and say, I don't know, having this convention. I mean, gee, I don't know what would be the first thing changed, or even the second or the third, and I might not be so happy about that. So we've never had one, and I think that's an excellent precedent.
I'm Richard Clary from Cambridge. A couple of weeks ago, sometime last month, Senator Whitehouse on the floor of the Senate described how at least part of your agenda at your workplace is set. He said that a few years ago, Alioto said in the dissent that it is time to re-examine a certain issue that we had long thought was settled. And when that happened, the Heritage Foundation and the Federalist Society organized litigation in the district courts that has now moving up through the system, so that the issue that Alioto wants changed will be decided. And now the Federalist Society got Garland out and Gorsuch in. And I'm wondering if that tactic, that makes you feel like you might be a bit player in the Heritage Foundation, Federalist Society agenda.
I'm tempted to say, I think if all of us, and the 9 of us, think we're bit players, that might be a healthy development. Right, I see it. No, the way we take courses, I mean, we don't think we're being manipulated. I mean, the way we decide what to take. I mean, we get about 8,000 requests, but it's easier to handle than you think, because they come in 150 a week. That is little booklets, 15 pages, why you should take it, 15 pages, why you shouldn't, and 150 a week. We give them to the law clerks. The law clerks, 30 in the building, 30
I'm only talking about the ones that Alioto is interested in.
Alito, it's Alito. And he's very nice, and we get on very well. But you'll see in a second. I'm telling you some reasons. So I go through this stack. I have the things over there. But I'm looking to see this, for this. And Chief Justice Taft, after he was president, became Chief Justice. He said what he thought the role of the Supreme Court is. And the role of the Supreme Court, he said, is almost exclusively, to decide cases where different lower court judges have come to different conclusions on the same question of federal law. That's why we can get through those 150 so quickly. We're not there to correct mistakes. We're there because they've already had a trial, they've already had an appeal, they've probably had 2 appeals. We're really there to see if there are differences. Well, sorry. That is what we do, right? Differences in federal law. So I can spot that pretty quickly. And the 9 of us can spot those pretty quickly. Now, I mean, that's why we might have a case. What is this comma in the Internal Revenue Code? Does it mean the next word should be a which or a that? And you see, there's a difference of opinion in the circuits on that. I like that case. No one else did. But but they can be that, or they could be Guantanamo. And you will read about the Guantanamo. Now, there are some exceptions. If somebody holds a statute unconstitutional, a statute of Congress, probably will take it. And there are some exceptions, okay? So, it's more by the rule, which is a rule that has nothing to do with an agenda, than people think. Now, if you said nobody could ever plan out a course of litigation where they're trying to get a constitutional rule changed, we would still be, I guess, living with separate but equal. Because the great genius of the Thurgood Marshall, the Legal Defense Fund, and the NAACP is there. I just was reading that the other day because I had to give a talk about Thurgood Marshall. Their genius was they started well in advance. And they said, look, It says here equal protection of the law. Well, it isn't. And they started with the law schools because they knew that the judges would know that that isn't equal. And they win that case, and then they went up to the next one, and finally they went to public education and Brown and 3 other schools, and they got there, and Thurgood Marshall went through the arguments and said, what argument? What argument? What argument is there for this? Because they're saying, well, we've always had it this way. Oh, well, first we haven't, but regardless. Is that an argument, or is that just prejudice? He says it's prejudice. That's what it is. Pure prejudice. And he forced, he says, because most of the judges didn't want that anyway. I mean, they knew, but I mean, they wanted to be unanimous. So this was planned. Not all of them, very few, very few. But fine, if people want to go and try to stir up litigation or something. There are rules that try to keep that down. Unless somebody's really hurt, they can't bring a case. So you can't just have a theoretical case. But sometimes the planning of it. In the particular case you're probably thinking, oh, well, we didn't decide, did we? It's a labor case.
Thank you so much, Justice Breyer. We're going to have to wrap it up. We wanted, because this is a family-friendly event, and I thank everybody for standing in line, we wanted to bring up the child to ask the last question, or the young person, I should say.
So, current times, since you were the assistant special prosecutor for Watergate, what do you think about the current situation?
Well, that's a great question. You think I'm going to answer that question? No. I could say I have no thoughts, but that isn't true. I do have thoughts, but on questions like that, see, we're supposed to stay out of anything that's political. If it comes up in a case, then even then you can't talk about a case that's going to come up. But because we have a process for deciding cases, and sometimes when you see the case and think about it, read the briefs, it's not always what you thought it was going to be at the beginning. So, if it were a case, I couldn't talk about it. If it isn't a case in political, I can't talk about it. And therefore, I can talk about almost nothing. But thank you very much for the question. Very good.
Thank you, Justice Breyer. We have a gift for you. And everybody, if you can please remain seated while the justice is escorted out. And I also want to thank the Friends of the Cambridge Public Library for supporting today's Democracy Day.